Hello everybody! We are back with part 2 of the two-part series about the implementation of private international law in ASEAN, this time explaining about Indonesia, Singapore, and Brunei Darussalam. Let's first begin with the implementation of private international law in Indonesia. The personal status in Indonesia is determined by the principle of nationality since the promulgation 16 AB. The application of the principle in cases of private international law in Indonesia is not as stern. The judges in Indonesia is also considering the other principles in private international law in determining the applicable law of a person, such as the principle of domicile in relation to marriage and habitual residence in relation to adoption. The application of the principle of nationality will be different if the judges must adjudicate the cases of the person who his states applies the principle of domicile. The renvoi or remission or even transmission could be appearing in Indonesia since Indonesia accepts such appliance pursuant to its jurisprudence. In contrary, Netherlands closes the appliance of renvoi. In relation to the academic bill, it is advisable if the international conventions which Indonesia becomes a party of could be referenced as the international instrument. It is also advisable if it could adopt the stipulation of international convention as described above. In details, it will be prudent if the academic bill could be compared side by side with the prevailing regulation so it will not contradict with one another. So as an example, we chose the matter between two Indonesian legal entities, which is PT Asuransi Harta Aman Persada, which we will refer to as PT AHAP, against PT Pelayanan Mana Lagi, which we will refer to as PT-PM, which is based on the Supreme Court Decree number 1935K Perdata 2012 that was decided on the 14th of January 2013, connected to the topic of choice of law in Indonesia. To sum it up, KM Bayu Prima was struck by fire which resulted in the losses of PT-PM. Therefore, PT-PM submitted a claim to PT AHAP as the insurance underwriter. However, PT AHAP refused the payment with the reason being that there was an important information regarding the year of shipbuilding which PT-PM had not informed to PT AHAP. In response to this, PT-PM filed a breach of the contract against PT AHAP to the Central Jakarta District Court. Unfortunately for PT-PM, the Supreme Court in its decision granted PT AHAP's appeal and cancelled the decision of Central Jakarta District Court and Jakarta High Court. Furthermore, the panel of judges at its cassation level heard themselves that the Central Jakarta District Court was not authorized to examine and adjudicate this dispute and stated that PT-PM's lawsuit was not acceptable. In its consideration, the Supreme Court judges stated that the agreed insurance agreement was valid as the law of the parties as stipulated in Article 1338 Burgerlijk Wetboek. Because the parties had agreed to choose English law in the insurance agreement, Central Jakarta District Court was not authorized to examine this dispute because the lawsuit should be filed in a British court.
The common law principles on choice of law for contract which are applicable in Singapore private international law are for the most part well established. Contracting parties express or inferred choice will be given unless the choice was not bona fide or was illegal or against public policy. In its absence of choice, the contract will be governed by the country or system of law that has the closest connection with the transaction and the parties. Three specific points where principle differs from the common law should also be considered. First, under principles, the choice of law must be made expressly or appear clearly from the provisions of the contract or the circumstances. Secondly, under the principle, the choice will be given effect to unconditionally, subject only to the overriding mandatory rules and public policy of the forum. There is no scope for the common law doctrine of limiting the choice to one that is bona fide, legal, and not against public policy. Thirdly, under the principle of governing law will supply the law on the limitation and prescriptions of time. This might be thought to be consistent with Singapore law after the Foreign Limitation Periods Act. As an example, we are bringing up the dispute about choice of law for interstate succession and presumption of similarity in foreign law. Ong John Rebecca Philip Lai Hua. This was a factually complex case relating to interstate succession. The plaintiff is the wife of the second defendant. He was a resident in Singapore but domiciled in Indonesia when he died interstate in Indonesia. In 1989, the second defendant executed a deed of release in which he purported to acknowledge receiving from the administrators of his father's estate certain sums in full and final settlement of his interest in the estate, and purported to discharge and release the administrators of the estate of their duties and obligations. Further, in 1991, under a deed of assignment, the second defendant assigned to the plaintiff one half of all his entitlement to the distributive share of the residuary estate of the deceased and all other rights in or to the said estate. The court made a number of observations. Firstly, immovable property located in Singapore will be distributed according to the distribution rules in Section 7 of the Interstate Succession Act. Secondly, movable property located in Singapore will be distributed according to the distribution rules in Section 7 of the Interstate Succession Act if the deceased was domiciled in Singapore. Thirdly, immovable and movable property located outside Singapore will be distributed according to the common law, choice of law, rules on interstate succession. Finally, the movable property located in Singapore will be distributed according to the common law, choice of law, rules on interstate succession if the deceased was not domiciled in Singapore. In this case, the immovable asset in the deceased estate in Singapore will be distributed according to the distribution rules in Section 7 of the Interstate Succession Act.
Implementation of private international law in Brunei Darussalam. Brunei has, like Malaysia, a Contract Act and a specific Relief Act which are identical in all substantive respects. Brunei has adopted the UK Unfair Contract Terms Act 1977 or UK UCTA as part of their law. The relevant law on exclusion clause in Brunei is the Bruneian Emergency or Unfair Contract Terms Order 1994, in addition to reenacting the provision of the UK UCTA, the salient feature of the UK Misrepresentation Act 1967 are also reenacted and would only have to be read together with the Contract Act. Brunei has signed the Hague Convention abolishing the requirement of legalization for foreign public documents, but Brunei is not party to the Hague Convention on Protection of Children and Cooperation in Respect of Inter-Country Adoption. As a case example, the New South Wales Court of Appeal recently handed down its decision in the interesting forum non-convenience case of Gersek PT Ltd v. His Majesty the Sultan of Brunei. The case arose out of an illicit contract for the sale of an old, rare and beautiful manuscript copy of the Quran by Gersek to the Sultan for $8 million. Gersek alleged that the Sultan has failed to perform the contract and took action in Supreme Court of New South Wales against the Sultan for specific performance. However, there was disagreement among the judges of the court as to whether, if the immunity had been procedural such that it would have been applied in Brunei but not in New South Wales, this would have a tend against conclusion that New South Wales was forum non-convenience. This raised the broader issue of the weight to be given to the unavailability of an alternative forum and the correctness of the view that ordinarily an applicant for a stay on forum non-convenience ground must identify an available alternative forum in order to obtain a stay.